Welcome to McDermott, Will & Emery's fourth quarter trends in data privacy litigation update. I'm David Saunders, a partner in our global data privacy and cybersecurity group based in Chicago. Let's get started, shall we? And where else to begin other than with BIPA, Illinois' Biometric Information Privacy Act. These cases continue to inundate the state and federal case courts here in Illinois. We've got a huge volume with the latest trend continuing to be facial biometric try-on cases. Now, if BIPA weren't already complicated and headache-inducing enough for defendants, now we've got two different statutes of limitations to contend with. The First District Appellate Division recently held in Timms versus Black Horse Carriers that Section 15A, B, and E claims of BIPA are subject to 5-year limitations periods, whereas Section 15C and D claims are subject to a 1-year limitation period. And of course, there's still the Third District Appellate Division, which is pending with the same question about statute of limitations. So we might get conflicting rulings, we might get a different ruling. It's very unclear. We're also, of course, still watching the Illinois Supreme Court and the Seventh Circuit, both of which have fairly significant appellate issues still before them related to the impact of workers' comp on BIPA, as well as when a BIPA claim accrues. Now, let's move on to COVID, because of course we're going to talk about COVID in this day and age. What has COVID got to do with data privacy litigation, you might be asking? Well, there are a couple of interesting issues. The first is plaintiffs try to keep their own identity confidential. The second is one of the claims that they're making in these COVID vaccine mandate cases is that entities shouldn't have a right to know what an individual's vaccine status is because of HIPAA or some other state law. Not that HIPAA is a state law, but you understand. Thankfully, I think for many of us, vaccine mandate cases have by and large gone for the defendants, with vaccine mandates being upheld in most of these cases, in fact, nearly all of them. The US Supreme Court has thus far stayed out of this foray, but as they say, it only takes one. And so I anticipate that plaintiffs are going to continue to try these cases to see if they can get an outlier. Now, moving on to what I think is the more interesting trend in data privacy litigation is we're moving beyond the bread and butter of data breach litigations into data use litigation. Plaintiffs are starting to sue because of the way entities are collecting or using information, as they allege, contrary to state or federal or international law, or contrary to a consent or some other disclosure that the company made. So, for example, in Prismall versus Google UK Limited, plaintiffs allege that Google obtained confidential medical records in violation of UK data protection laws. Similarly, in Louth versus NFL Enterprises LLC, plaintiffs claim that the NFL is sharing mobile users' personal information with Google in violation of federal and state law. Now, Google is just being picked on here, but they are definitely in the spotlight as big tech, as are any other big tech companies. And I anticipate that we're going to see a raft of these litigations where people are not challenging a data breach, but rather the collection and the use. And that's going to become sort of the larger set of data privacy litigations beyond data breach. But of course, this wouldn't be much of a data privacy litigation update if we didn't talk about data breach litigation. There were two interesting updates in this last quarter that I want to focus on. The first is in Fireman's Retirement System of St. Louis versus Sorensen, pending in the Delaware Chancery Court. The court there granted a motion to dismiss breach of fiduciary duty claims against Marriott former directors related to the Starwood data breach. There's a significant case because it draws lines for boards of directors as the potential liability for their cybersecurity of their company. Now, in In re Blackbaud, I think the more interesting in these two rulings last quarter, we've had a court grant a motion to dismiss on some claims and deny a motion to dismiss on other claims. But I want to focus in particular on the negligence claim. Now, for those of you who don't know, Blackbaud was essentially a database vendor. It aggregated the information for, in particular, a bunch of nonprofits and held donor databases and the like for them. The court in re Blackbaud recently ruled that there's a special relationship that existed between In re Blackbaud and the individuals whose information were being hosted by Blackbaud. And as a result, those individuals could pursue a negligence claim. Now, what's interesting about this is I think it's going to invite test case litigation to see how far this special duty in Blackbaud can extend. Does it apply to other aggregators? Does it apply to cloud service providers? It's an interesting question. And I think we can anticipate that some plaintiff somewhere is going to test that question. So the other question that we always ask when we talk about data privacy litigation is, when is it going to end? Are we going to get a federal privacy law that adds some clarity and stops some of these frivolous filings? No. So check back next quarter for more updates. And if you find yourself on the wrong side of the V, as they say, my contact information is available on our website, and you can see it below.